I now call on Fergus Ewing to wind up on behalf of the Government. Minister, you have until 5 o'clock.
Thank you very much, Presiding Officer. I am extremely encouraged by the consensual tone of this afternoon's proceedings, and I am sure that that will not go unnoticed in Parliament House. This Parliament is at its best when it's acting and debating in this way, I believe, and that tone was present in the last civil justice debate led by Cathy Jamieson back in 2006. And before I turn to today's proceedings, it might just be helpful to recap some of the calls which were made in that debate and what has happened since. In that debate, Margaret Mitchell called for an arbitration bill. Yesterday we had the Stage 2 debate in an arbitration bill. Mike Pringle called for an increase to small claims limits. A fourfold increase was effected within 6 months of our taking office, thanks to the consensual approach that was adopted under the avuncular convenership of Bill Aitken in the Justice Committee. Nigel Donn today has indeed raised a point, perhaps not in Lord Gill's report, about increasing further the privative limits of small claims and summary cause from 3,000 and 5,000 perhaps to higher level. I think it's 10,000 in England. Christine Graham and many others called for an increased financial support for advice centres. Presiding Officer, earlier this year we announced an additional £3 million of new funding. Mary Mulligan and Jeremy Purvis called for a broadening of the access to civil legal aid, and many members have rightly stressed the importance of access to justice in their contributions today. Now, we have broadened access to civil legal aid. Now, nearly three-quarters of households are now potentially eligible, compared to 43%, I am assured, before the changes were made. I understand from officials that applications for civil legal aid are up by one-third, 33%, in the last 6 months, compared to the same period last year. John Swinney called for implementation at last of sections 25 to 29 of the Law Reform Miscellaneous Provisions Act 1990 and rights of audience. That has now been done. Bill Aitken called for increased legal aid rates for solicitors. Bill Aitken, the defence lawyer's friend. We have made those changes too. I hope we can make further progress, Presiding Officer, acting together. Scotland's senior judiciary are recommending this course of action to us in the interests of justice, in the interests of the nation, and some radical changes to the way in which the civil justice system operates. I should, I guess, follow Gavin Brown's declaration that I am on the roll of solicitors, although I fear my practising days are long over. But I do recognise, I absolutely recognise the picture that Lord Gill has painted of our civil justice system. I recognise it as a system which, sadly and all too often, is characterised by delay, worry and expense. And, as Lord Gill opines in paragraph 2 of the introduction of his report, reform is long overdue. An efficient civil justice system, he says, is vital to the Scottish economy, but it is also vital to the survival of Scots law as an independent legal system. If it's the case, as Gavin Brown argued, that some of our major commercial operators in Scotland find the experience of litigating so appalling, so dreadful, so expensive and so slow that they choose never to litigate here again, then we cannot really expect that our legal system will necessarily have a right to survive forever in perpetuity. No one owes us a living, and no one owes our lawyers a living. The system that we have must not be a system, a civil justice system, which operates for the convenience of lawyers, judges and insurance companies. It must be a system which operates for the client, the customer and the citizen. Now, there are those in this chamber who will instinctively and rapidly agree with some of Lord Gill's recommendations, whether that is the decluttering of the Court of Session, the judicial continuity through docketing, one sheriff, one case, seeing it through to the end rather than several sheriffs considering the same case with the disruption that is necessarily heir to. Specialised courts, and many contributors have rightly mentioned that today. Multi-party actions, Shirley Ann Somerville devoted her contribution to that in a very balanced way. Simplified procedures in the lower courts, or the ability for party litigants to call on Mackenzie friends. Each of these, and many of the other recommendations, will all find their advocates, perhaps impatient for changes to be introduced. What I found encouraging about today's debate is that everyone recognises that we have to consider these matters extremely carefully, and we will do. And let me reiterate what the Cabinet Secretary said at the outset, that we have made the offer, and I believe the offer has, if you like, been accepted across the floor of this chamber, thereby forming a verbal contract that we will, one to which we will doubtless be held, to meet with spokespeople from each of the parties, and indeed individual members if they have significant contributions to make, because we wish to progress this in the consensual manner that we have seen in this debate today. I would like to respond to some of the contributions that have been made. With regard to multi-party actions, the Scottish Law Commission actually recommended that these should be taken forward in the year 2000. The Court of Session declined to adopt that at the time, concluding that current assisting, postponing mechanisms seemed to work well and had dealt well with multiple actions, including Piper Alpha. Lord Gill's recommendation will no doubt give cause for the Court to think again, as will developments likely in forthcoming UK Government proposals for consumer protection in financial services. I think I'm right in saying that the 700-page report did also allude to the fact that had